The Fluoride Deception, Chapter 14, Fluorine Lawyers and Government Dentists. A very worthwhile contribution. Although big corporations have long used the US government's medical assurances about fluoride safety to defend themselves in fluoride pollution cases, no collaboration between industry and the federal promotion of fluoride has ever been acknowledged. However, Robert Kehoe's papers show precisely such collusion, detailing how the fluoride research of the National Institute of Dental Research, ostensibly conducted to prove water fluoridation safe, was covertly performed in concert with industry, which was aware that the medical data would help their fluorine lawyers battle American pollution victims and workers in court. The Reynolds Metals Company employed a legal strategy during the Martin case that would become a staple in American courtrooms. 5 years had elapsed since the Federal Security Agency Administrator Oscar Ewing, the former Alcoa lawyer, had endorsed public water fluoridation on behalf of the Public Health Service, which was under the FSA's jurisdiction. During the 1955 Martin trial in Portland, Reynolds reminded the court of fluoride's beneficial effects. Fluoride was being added to toothpaste, and 15 million Americans now consumed more fluoride through their drinking water than the Martins had been exposed to, Reynolds' attorney said.
This court has thus found to be poisonous an amount of fluorine which scientific and judicial opinion has unanimously found harmless,
Reynolds' lawyers argued.
The only thing not explained is how the Martins could have suffered injury from something harmless to the rest of mankind,
they added. Robert Kehoe also understood how public water fluoridation helped industry. His endorsement was featured in the profluoridation booklet, Our Children's Teeth. That booklet was simultaneously distributed to New York parents and to the judges on the Martin Appeals Court.
The question of the public safety of fluoridation is non-existent from the viewpoint of medical science,
he assured parents and judges alike. Privately, however, Kehoe was not so sure.
It is possible that certain insidious and now unknown effects are induced by the absorption of fluorides in comparatively small amounts over long periods of time,
he had told industry in 1956. And in 1962, Kehoe told Reynolds' medical director, James Macmillan, that there remained
a basic question concerning the non-specific effects of prolonged exposure to apparently harmless quantities of fluoride.
This, by the way, is the thing on which George Walbot bases his entire campaign against fluoridation. Kehoe and his Kettering laboratory continued to soldier for water fluoridation during the 1950s and 1960s, assailing fluoridation critics as windbags and windmills. Kettering toxicologists Francis Heiroth and Edward Largent were prominent members of National Academy of Sciences panels that endorsed fluoridation. And in 1963, the Kettering Laboratory published an influential bibliography of the medical literature favoring fluoridation, entitled The Role of Fluoride in Public Health, The Soundness of Fluoridation in Communal Water Supplies. Kehoe saw how fluoride safety studies performed by government dental researchers helped his industry patrons in court. Farmers and workers would have a much harder time successfully suing corporations for fluoride pollution if the U.S. Public Health Service had performed its own studies and then vouched for the chemical's safety.
The results of such dental investigations are highly advantageous,
Kehoe explained to the corporations sponsoring his fluoride work at Kettering,
in that the problem of proving fluoride safe exists outside of industry, thereby involving situations in which the economic factors tend to be of different type and significance than those which are often alleged to be active in the industrial world, and often involving investigators who are not subject to accusations of bias based on industrial associations.
Kehoe approached the Public Health Service in April 1952 on behalf of the industries sponsoring his fluoride research to ask that the health agency perform additional fluoride safety studies.
I was requested by the group of industries for whom I have acted as a spokesperson and chairman in the consideration of this work to approach your division of the U.S. Public Health Service with the idea of determining whether or not an investigation of that type might not be conducted by the service,
Kehoe wrote to Dr. Seward Miller. Government proved cooperative. The top medical investigator at the National Institute of Dental Research, Dr. Nicholas Leone, was especially helpful. In August 1955, for example, during the Martin trial, the public servant Dr. Leone spoke with a senior attorney for Reynolds Tobin Lennon, who also was a member of the Fluorine Lawyers Committee, directing Lennon to a federal safety study on fluoride that Leone had recently concluded in Texas. No record could be found of anyone from this U.S. government agency ever helping the Martin family. Leone's study had examined people living in 2 Texas towns where there were different amounts of natural fluoride in the water supply. The town of Bartlett had between 6 and 8 parts per million in its water, while nearby Cameron had 0.4 ppm. Dr. Leone had given both towns a clean bill of health, reporting in 1953 that no harmful, significant differences were seen in the 2 populations. Although George Walbot and others had vigorously attacked the study's scientific method and conclusions, the so-called Bartlett-Cameron study became, along with Harold Hodges' Newburgh study, a linchpin of the government's case for water fluoridation, medical proof that adding fluoride to water would be harmless. As the Martin trial hung in the balance, the government's Dr. Leone burned up the long-distance telephone lines to Oregon, answering questions from Reynolds' attorney Lennon on the findings of the Bartlett-Cameron study. Dr. Capps had testified on Paul Martin's behalf that fluoride had injured his client's liver, so Reynolds' lawyer wanted information about fluoride's effects on such soft tissues. Although the Bartlett-Cameron study had not examined soft tissue, such data would soon be at hand, Leone reassured industry. New government-funded studies were in the pipeline, and they spelled good news for the Fluorine lawyers. In the spring of 1957, as corporate America awaited the Martin Appeals Court verdict, Alcoa's Dr. Dudley Irwin traveled from Pittsburgh to the sparkling new campus of the National Institutes of Health in Bethesda, Maryland, to meet directly with Dr. Leone and discuss the current status of the fluoride problem. Irwin was the medical coordinator for the Fluorine Lawyers Committee. Dr. Leone laid out the plans for the new fluoride safety studies that the Federal Dental Agency was then readying. The 2 men then discussed how those studies could be presented to best suit our purpose, according to a March 5, 1957, letter Leone sent to Irwin to thank him for his visit. In particular, Leone gave the Alcoa doctor details of a human autopsy study then being conducted in Provo, Utah, in which soft tissues were being analyzed. Leone was serving as a consultant to the Utah study, he wrote, and he had personally designed the autopsy protocol.
The interests of the Provo group,
Leone explained in his letter,
relate directly to atmospheric pollution of fluorides and its effects on humans. As you know, it has been proven beyond a question of a doubt that similar conditions have an effect upon animals.
Irwin paid close attention. Provo was the site of perhaps the most serious litigation problem then facing the Fluorine lawyers. Since World War II, when a mighty steel plant had been located in the Utah County Valley near the city of Provo, far from any threat from Japanese bombers, local farmers had been in an uproar over pollution that they claimed had decimated their cattle. By 1957, the Columbia-Geneva division of U.S. Steel had settled 880 damage claims totaling $4,450,234 with farmers in Utah County. An additional 305 claims for a further $25 million were filed against the company. Nicholas Leone's researchers, working on a PHS grant, were studying the soft tissues and bones of Utah County residents, he told Irwin.
Inmates of a mental institution close by comprise the study material,
he added. The Bethesda meeting between Alcoa's fluoride doctor and the government scientist went well. They made plans for a future rendezvous.
In view of the vast amount of material soon to be available for publication,
Leone concluded in his letter to Irwin,
we are all very enthused about a group presentation at some carefully selected meeting in the near future. I believe we discussed that briefly while you were here, and I hope that you have had opportunity to give further thought to the type of meeting that would best suit our purpose. A one-shot presentation and publication in a single issue or monograph should be of more value than publication in a number of publications. Again, it was a pleasure seeing you, and I hope we have the opportunity for further discussions in the near future. Best personal regards. Sincerely, Nicholas C. Leone, Maryland, Chief Medical Investigations, National Institute of Dental Research.
The government scientist enclosed a gift, a copy of a science fiction novel called The Pallid Giant by Pierre-Pont B. Noy. Alcoa's doctor was jubilant at the letter. The government studies would show no harm from fluoride, he had learned, almost certainly from Leone himself. Irwin immediately contacted the Fluorine Lawyers Committee boss, Frank Siemens in Pittsburgh, forwarding to him a copy of the letter he had received from the NIDR's Dr. Leone. Thrilled at the news from Washington, Alcoa's top doctor explained to Siemens, in a letter dated March 13, 1957, exactly how the nation's water fluoridation program and accompanying health studies might help American industry.
These clinical investigations pertain to basic studies of individuals residing in areas where the fluoride content of the drinking water varies from 0.04 ppmf to 8.0 ppmf. You will appreciate that this range of fluoride exposure brackets the range in which a number of us are interested. I have reason to believe the results of these investigations will show no evidence of deleterious effects due to fluoride absorption. The publication of these results will be a very worthwhile contribution,
wrote Irwin. The obliging government dental researcher, Dr. Leone, wanted to share the good news with a restricted group of industry friends, Dr. Irwin told Alcoa's lawyer.
Dr. Leone has given me his permission to supply copies of this letter to you for distribution to your group of Fluorine lawyers on a confidential basis,
he wrote Siemens. Any jubilation in the ranks of the Fluorine Lawyers Committee, however, quickly turned to fresh panic. The following month, on April 24, 1957, Judges Denman, Pope, and Chambers of the Federal Appeals Court for the Ninth Circuit in San Francisco upheld the lower district court ruling in the Martin trial. Their verdict was that Reynolds Metals was guilty of negligence and of poisoning the Martins with fluoride. In a gesture even more frightening for industry, Judge Denman cited a legal principle known as absolute liability. It meant that industry was responsible for resulting injury, whether accidentally caused or not.
The manufacturer must learn of dangers that lurk in his processes and his products,
wrote Judge Denman, in his opinion upholding the district court.
It was the duty of the one in the position of the defendant to know of the dangers incident to the aluminum reduction process,
the opinion added. Frantic, industry scrambled back to the courts. The entire Ninth Circuit Appeals Court, en banc, all judges on the appeals bench, not just a three-person panel, now confronted a stunning spectacle, as 6 top U.S. corporations paraded before them, pleading for relief. Alcoa, Monsanto, Kaiser Aluminum, Harvey Aluminum, the Olin Matheson Chemical Corporation, and a division of the Food Machinery and Chemical Corporation, each joined Reynolds in attacking the Martin verdict, filing an impassioned amicus curiae, Friends of the Court brief. 100,000 workers were employed in the U.S. aluminum industry alone, industry told the court, while 7 aluminum smelters in the Northwest were located in inhabited areas similar to the Troutdale plant. Judge Denman's ruling had impossibly tightened the screws on the economy and jeopardized the nation's Cold War military strength, the corporations argued.
The necessity of a strong aluminum industry to national defense is known to all,
their appeal noted. Judge Denman had
reached out and with one swift stroke branded the aluminum industry and all industries involving the use of fluorides ultra-hazardous,
it added. The industry attorneys warned of
the tremendous impact of this decision
and argued that
if Judge Denman's opinion placing absolute liability on these industries is to stand, the financial handicap so imposed may well impair their financial stability.
As industry's lawyers scrambled back to the courts, the government's Dr. Nicholas Leone from the National Institutes of Health hurried for an emergency meeting with industry officials at the Kettering Laboratory. He was accompanied by no less than the director of the National Institute of Dental Research, Dr. Francis Arnold. On May 20th, 1,957 a month after the Martin verdict, the public servants met for a relatively confidential discussion of the issues with Dr. Kehoe and a medical advisory committee of officials from the industrial corporations sponsoring the Kettering Laboratories fluoride research. This medical advisory committee had been established on behalf of the Fluorine Lawyers Committee by Alcoa attorney Frank Siemens. Alcoa's Dudley Irwin opened the meeting. He began by reiterating news of the Martin verdict. The U.S. dental investigators and the company officials reviewed the weakness of industry's position, according to notes taken by Dr. Kehoe. The group then discussed the Martin case in relation to the community problems of air pollution, water pollution, and food contamination, and the position occupied by industry in creating a new environment characterized by potential hazard to the public health, according to Kehoe. Industry was vulnerable, Kehoe emphasized to the dental researchers. He summarized the Kettering investigation of the Alcoa plant at Messina, New York, where fluoride had disabled workers. The results of this study had, and still have, never been published. There was a need, Kehoe told the NIDR's Nicholas Leone and Francis Arnold,
for research of a basic type to establish the facts on which medical opinion can be based, so that irresponsible medical testimony will be discouraged.
The government men took their cue. Doctors Leone and Arnold again laid out for industry the several pending studies the NIDR was conducting. The science was ostensibly being performed to demonstrate to the public the safety of water fluoridation, yet for the anxious men at the Kettering laboratory that spring day, there was a clear understanding that such medical studies could help polluters. The conference concluded with plans for an ambitious strategy to shape the national scientific debate on fluoride by hosting conferences, symposia, compiling new medical research for dissemination or publication, and arranging working sessions to decide what to do and in what sequence, according to Kehoe's notes. On June 5, 1958, the full appeals court in the Martin case gave some ground. It upheld the verdict that the Martins had been poisoned and that Reynolds was negligent, but it withdrew the earlier opinion that the legal theory of absolute liability applied. The final decision was still distressing. The Fluorine Lawyers Committee head, Frank Siemens, wrote to Kehoe in a melancholy note 8 days later. In an enclosed legal summary of the ruling, dated June 12, 1958, he concluded that the verdict
will doubtless have great significance in the further development of the fluorine problem.
There was, however, a solitary ray of sunshine. Perhaps the rollback of the absolute liability verdict would help industry in the coming decades.
We can now argue that the Martin case went off on its own particular facts and that it is not a ruling that an aluminum smelter is liable for damage, regardless of negligence,
Siemens wrote. Siemens believed that it was the visit and testimony of the English expert, Donald Hunter, that had delivered the knockout blow. The English doctor had left a perhaps disfiguring scar upon corporate America.
The court quoted from the testimony of Dr. Hunter,
Siemens wrote to Kehoe,
and said that his testimony was worthy of credit and, in fact, outstanding. These quotations from the testimony of Dr. Hunter about the effects of fluorine on human beings are very unfortunate and may serve to give such claims a push.
Kehoe was bitter about the whole affair.
I have rarely found myself in a more embarrassing situation than I was in the Martin case,
he told one of Reynolds's other witnesses, and he complained to a friend, Philip Drinker of Harvard School of Public Health, about the cleverness and histrionic character of Donald Hunter's testimony. The professor commiserated.
Hunter's exhibition was cheap Cockney showmanship at a pretty low point,
Drinker said.
Numerous friends in England have told me he was for sale, and he certainly sold himself for this,
he added. Dr. Kehoe would have his revenge. In the days after the Martin verdict, worried industry officials turned again to his Kettering laboratory for help. Industry stood on a precipice. The danger was clear, and so was the solution. A powerful new scientific orthodoxy must be forged to defeat workers and farmers like Paul Martin and remove the threat from independently minded medical experts such as Donald Hunter and Richard Capps.